And we are live and recording.
Okay, thank you. Good afternoon. My name is Judge D'Angelo. We are here on the single justice matter of Santander Bank versus Lisa Mackey. It's docket 23J247. Good afternoon to both counsel.
Good afternoon, Your Honor.
All right, so the issue before me is basically a bond appeal issue, so I will hear from Ms. Mackey's attorney first. Go right ahead, counsel.
Your Honor, so much of what I have to argue is already embodied in the actual motion to waive the appeal bond and to waive the use and occupancy, which is in the record before you. And I don't want to belabor and I don't want to take more of your time to recite everything. I don't know if you've had a chance to look at the overall procedural history of this litigation.
Mm-hmm. I have.
The problem really stems from a ruling out of the Superior Court, which followed a remand from the appeals court. The appeals court already at one point had said Santander thought that they were the owner based on a Superior Court ruling in 2018 and found out they weren't after already going forward on a foreclosure and bringing an eviction action. And while that was pending, they found out, gee, we don't own it. So they come back to Superior Court on remand, raised some issues that were raised before and probably shouldn't have been allowed at all, and raised one that they had raised for the first time on appeal. And the Superior Court made a ruling that we have appealed. The housing court ended up with the case because Santander decided, gee, let's run with this, and now let's evict her. And whatever ends up happening with the housing court really all depends on the appeal of the Superior Court decision. And what has happened here in the housing court, we did not challenge any of the procedural aspects of the foreclosure. The whole issue is, did they have a mortgage at all, or did they not, based upon the trustee who signed as purported trustee at the time, not having been the trustee. And if the Superior Court ruling gets overturned again, then they just didn't have a mortgage and the whole housing court thing disappears, except in the meantime, if they're evicting her or she has to pay use and occupancy that she can't possibly pay, then she can't really carry on the appeal out of the housing court. And then you can just imagine what a mess we're going to have if they've taken the property, foreclosed on it, sold it to somebody else, and it turns out they never owned it to begin with. That's really the issue.
Counsel, let me ask you, did you ever file a motion to stay in the housing court pending the Superior Court decision or the appeal of the Superior Court decision?
No. And maybe I should have. I never really looked at it. My feeling was that at some point when we get because I've appealed the order of possession. Mm-hmm. They had gone through a whole summary judgment about how all the proper things they did to do the foreclosure, which we didn't argue. We just said, but you didn't have the right to do it at all. And that's been appealed. And I did think that what we would be doing was when that aspect, when they say they've assembled a record and we enter that appeal in the appeals court, I would be moving then to hold up the scheduling for briefs and all that to see, let's just see what happens with the appellate decision on the Superior Court appeal, which truly governs what happens with the housing court order. The housing court felt that it was bound by the last Superior Court decision unless and until overturned. Because I had kind of argued, we already went to the appeals court. The appeals court already said once, hey, Santander, you're wrong. So that's where we are. So in arguing to waive use and occupancy, the real difference, and that's really, as I see this, that's what's before you today. The housing court judge's decision really shows that he believes he has to set a use and occupancy order, that he does not have discretion to not set one. And everything that I argued in the motion pointed out many times in the case that he relies on, Bank of New York Mellon versus King. And again, I mean, that tracks Davis versus Comerford, which talked about use and occupancy pending a jury trial, actually, in that case. And they all say the court has discretion. The court is not forced to make a use and occupancy order. The court can order all or any portion of what would be, we talk in terms of rent, but it applies to use and occupancy as well. And it may do this and it may do that. And the housing court judge really says, he says it's on page 3 of his decision, part 6. Occupant argues the court should set use and occupancy at a level affordable by occupants so that her indigency will not be a barrier to sustaining her appeal. And argues that she should pay only those carrying costs that she has been paying. I mean, that's a whole nother point. This is not a case where she was paying a mortgage amount for many years and then couldn't meet it and then they foreclosed. This has been an argument about ownership all along. But that aside, that issue was resolved by King contrary to occupant's position, requiring that the consideration given to her financial situation should not result in a sum representing less than a fair value of the use of the property. The amount found may be on the lower end of the range, but it may not be below a reasonable estimation of the fair value for the use of the property. I disagree. The decisions are very clear about the court having discretion to set an amount or to set all or part of the rent. Well, part of the rent could be $1. Here, he just felt that he had to set a number within the range that the evidence showed would have been a fair use and occupancy. We are not arguing that the amount that he set was not a fair amount for use and occupancy. We're arguing you didn't have to set it.
Well, counsel, let's assume that I agree with your position.
Yes.
That either I or the housing court judge can set use and occupancy at 0, basically pending the appeal of all this.
Mm-hmm.
If Santander ends up having the correct position, my court, not me on the panel, but another panel, agrees with Santander's position, where does that leave Santander during this potentially 1-year appeal process? Your client would be living in the premises for 1 year, in essence, rent-free. What do they do after the appeal is over?
Well, in the Superior Court, as for the Superior Court appeal, Judge, we had gotten our brief in that case actually ahead of time, just to make sure everything moved as quickly as possible. Santander had then moved for a 2-month extension. So I don't think they're agonizing over the money they're going to lose. The truth of the matter is their amount of their claim, which started out as a $400,000 line of equity, is somewhere in the area, I think, of $790,000. But their own expert testified the house is worth about $1 million. They're not going to lose money. If she makes no payment, and even if it took a year, and I can't imagine, and again, it's the Superior Court appeal. It's the appeal from the Superior Court.
Yep.
We've already done our brief. That's what's going to govern. I don't think it will take more than, say, 5 or 6 months, really. I could.
You're very optimistic, but that's fine.
I'm sorry. You know, I mean, the guys have a lot of work, I grant it. But of course, the issue is so clear and obvious. I'll just read my brief and say, you know, Najar's right. That's the end of it. So what do they do? Well, I'll tell you, this is very interesting because there's just a line out of King that the housing court cites that while we are mindful of the plight of the indigent, we are also cognizant of the fact the duty to care for the poor and the needy is on the state and not on the landlord. Well, here's what happened. Very recently, and this is extremely recent, the boiler one. And Lisa Mackey has gone to CTI to try to get the funds for like $16,000 to replace the boiler. So guess what? yeah, here's Santander, and she's going to the state to try to get, like she would have to go to try to get Section 8 or something of that nature, maybe a CTI program, to pay them, even if the use and occupancy were only set at, say, 1,500. So they're here we are, the government and the state benefiting Santander. If they want to be landlords, man, they're taking a heck of a chance, but that is the situation right now. She's been in it a long time. She's been maintaining it as best she can. She's been paying the insurance on it. There happens to have been an insurance loss on that day in this winter that dropped below like 20 below and the pipe burst. And that, thank God, because she maintained insurance, Santander did not. That claim is covered. We've actually told the insurer, you've got to wait because we got to determine who gets the money. We got to determine who owns the property. And we had suggested in the housing court that she should keep doing this and be paying the utilities and making sure the place doesn't fall apart and everything freeze in the winter and the like. And she can do that. And they're protected because the value of the house has sufficient excess in it that they're covered anyway. The other thing, well, one way or the other, and I've got to point this out, one way or the other, Santander has a stake in the house because James Mackey had signed the promissory note personally. He did not sign the mortgage personally, but he did sign the promissory note personally. And because of the way the divorce decree was, he still owns half the equity. They're going to get something no matter what out of this house. They're protected, Rich.
All right.
If you don't have any questions, I'm not going to belabor it. It's in there. I just feel there are so many times in Bank of New York versus Mellon that they talk about what the court may, it's the court's sound discretion. And the housing court judge just felt that his discretion is limited to working within a range as opposed to saying, gee, the important thing is here. I mean, it's an unusual case. This is not your normal foreclosure. This is not like, I think it was the other case I cited there, Davis versus Comerford, where the court saying inevitably the person's got to get out of there. They couldn't pay their mortgage. That's not the situation. So with that, I mean, I said I wouldn't take much time. I've taken almost all of it. So.
That's okay. Thank you very much, counsel. Attorney Kane, I'll hear you.
Good afternoon, Your Honor. Thank you very much. First of all, just to respond to Mr. Najar's recitation of the procedural history, and I feel obligated to do this every time he says it, but the appeals court has never invalidated Santander Bank's mortgage. This has always been in the Superior Court a declaratory judgment action by Lisa Mackey to invalidate the mortgage. She lost on summary judgment once. The appeals court vacated, they did not reverse, and remanded. She lost on summary judgment again, and we're now on appeal again. If it's vacated again, it is still not the case that the mortgage has been invalidated. She still bears the burden of proof on that issue, and she's never met it at any level. And if we get vacated and remanded, we'll be off to trial. So to say that if we lose at the appeals court, the foreclosure is invalid is simply not the case.
I understand that. Let me see. And again, I'm certainly going to let you argue. I've read all the papers, but there are a few things I have to decide, obviously.
Of course.
Do you agree that there is at least a meritorious issue on appeal?
No, I do not. And it's important to point that out because this is de novo. So you can go back to the beginning. And before we even get to waiving the bond and considering use and occupancy, Ms. Mackey's got to meet the statutory factors. She's got to prove that she's indigent. That's a given. Well, it's not a given, but it was accepted and I'm not contesting it. She also has to prove she has a meritorious appeal. For a very clear reason, she does not. And that is res judicata, black letter law, bars her from appealing this judgment for possession because her only argument is that the mortgage is invalid. But that argument is barred by the Superior Court judgment. It just is. It doesn't matter that the Superior Court judgment is pending on appeal. The Supreme Judicial Court in O'Brien versus Hanover, a 1998 case, said a trial court judgment is final and has preclusive effect regardless of the fact that it is on appeal. So applying that black letter res judicata principle to her putative appeal from the housing court, I can't fathom any merit. To me, it seems entirely frivolous because res judicata kicks it out immediately.
Well, that's an interesting point, and I'm going to do what I did to Attorney Najar.
Sure.
I understand your perspective, but what if a colleague in my court who's writing the decision agrees with Ms. Mackey's position and ultimately not only remands the case back to Superior Court, but says the mortgage is invalid? And you've already persuaded me, I guess, to leave your client in there. What would then happen?
So there are some assumptions there that I want to clarify. If the order of the housing court is affirmed and the appeals court later declares the mortgage invalid, or the Superior Court does, my client is not insensible to the fact that this is risk of having its mortgage pulled out from underneath it and having the foreclosure therefore invalidated. That's a serious risk that my client will have to consider, but they have the right to consider that, and they have the right to take that risk, and they'll do it with the advice of counsel, and they'll decide what they want to do. But the fact is, they shouldn't be precluded from taking whatever action they want to take, number one. And number two, if they win on the appeal from the Superior Court, as I expect they should, having a ready judgment and execution in the housing court will finally put to rest an issue that's been going on for more than 10 years. I mean, the equities are one of the factors that King lets the court consider. And I think it's worth pointing out. And let me say, I like Miss Mackey. I've met her. I think she's a nice person. I think she's been, the victim of some bad treatment by her husband. I don't think Santander has wronged her in any way. And I think the fact that she has lived in this property, mortgage and rent-free for 10 years, is enough from Santander's perspective. I get that. And so I think that's important to consider. And having the housing court judgment in hand, having an execution in hand, if assuming my client decides not to levy that pending the appeal, then we have an end date. We have an exclamation point. At the end of this litigation, we can move forward and be done. That's very important to my client. And so for that reason, so we've sort of now talked around two issues. So to back up, number one, there is no meritorious issue here, res judicata. Number two, I would not assume as the court that blocking the appeal on the assumption that she can't make the use and occupancy payments that have been ordered will result in her eviction. That's a choice that my client would still need to make. And I don't know what choice they would make, but I'm certainly cognizant of the risks involved. I know Mr. Najar is, and Ms. Mackey, I'm sure, is too. So that's that. If I'm happy to discuss why I think Judge Malamut correctly applied King, if the court wants to hear that. And again, this assumes that you find a meritorious issue on appeal, because King is only relevant if we're talking about use and occupancy.
Yes. Let's assume I find that there's a non-frivolous issue on appeal. What do you say to Attorney Najar's position of it's not an either, it's not that I have to set a use and occupancy, I have discretion. I take it you disagree with that point.
I don't disagree that you have discretion. I do disagree that you have discretion to zero. And for a couple of reasons. First of all, Davis versus Comerford is a landlord-tenant case, not a post-foreclosure case. And King is a post-foreclosure case. What King says, and more importantly, what the statute says, 239 section 5E, I'll start with the statute. The court shall require any person for whom the bond has been waived to pay in installments rent, which shall become due after the date of waiver. That's a statutory requirement. King, based on that, this is a quote from King, the party for whom the bond has been waived must pay rent in lieu of a bond. Must. Now, King talks at great length about balancing the policy interests and how it would be frankly unfair to saddle the owner with the fact that the occupant is indigent. And that's correct. And I think Judge Malamud correctly gleaned from that policy discussion that while it's okay to consider the financial circumstances of the occupant among the other factors that King talks about, it's not okay because of the policies underlying King to take that factor and then reduce the rent to zero based on that factor. I think what he did with that factor is exactly correct and exactly appropriate, which was to say, I've heard evidence on this. Here's what I think the range of appropriate fair market rent would be. And based on the financial circumstances of the occupant that have been presented to me, I'm going to go to the floor of that range. He said, I've got a 10% range, so I'm reducing it 5%, right to the floor of that range. That's what he did. And I think that was the correct way to apply that factor under King in light of the policies that King embodies. And that policy is we need to fairly balance the interests of the owner with the interests of the occupant, having in mind that it's not the owner's problem that the occupant may be indigent. You know, we don't want this to be a bar to appeal, but even having said that, King goes on, it's not the owner's problem if they're indigent. And so I think what the judge did in the housing court was exactly right. And I would affirm his decision outright to the extent you do find a meritorious issue on appeal. And unless the court has any other questions, I'm not inclined to take up any more of your time.
Great. Thank you both very much. The paperwork that was filed was excellent, and you both argued fantastic. And I will try to reach a decision immediately for you both.
Thank you very much, Your Honor.
Thank you very much.